both my wife and I are physicians, so we are doubly concerned about medical malpractice. And we both also bought new cars relatively recently. Ideally, those assets would not be exposed to our creditors. But unfortunately, your book lists that in our state of Florida, you only have about $1,000 of automobiles protected. And $1,000 doesn't get you a whole lot these days with cars. But you also discuss how tenants by entirety is an option in our state. When we purchased the vehicles, I thought I had set it up under tenants by entirety, but in hindsight, I think I did it incorrectly. So I had the dealerships put both of our names on the car titles, but looking back at them, they put an or in between our names rather than an and in between our names. So the car title says husband or wife rather than husband and wife. Is this something that I could just go to the DMV to fix, or is it too late? Is this something that you have to do correctly from the start, or it's not going to work at all? Thanks.
All right. Let's talk about asset protection for a minute. Remember that asset protection strategies, once you get beyond insurance primarily, require you to declare bankruptcy in order to work, or at least be willing to threaten to declare bankruptcy. The idea that you have these assets that are exempt, retirement accounts, homestead exclusions, tenants by the entirety kind of strategies, right? The assumption here is that you go to the creditor, this person that has a judgment against you, and you say, if you keep pursuing this, if you don't settle for some tiny amount, I'm just going to declare bankruptcy and you're going to be stuck. So this isn't something that you do willy-nilly. This is a big deal when you are actually using these strategies for asset protection. If you actually have to implement this strategy, life is not going well for you, right? It means you've got some huge judgment against you, more than, in the case of a car sort of thing or a malpractice sort of thing, more than what you have in personal liability through your umbrella policy, more than you have in your malpractice policy, et cetera, right? So this is a huge judgment against you. You owe somebody $10 million or something, and you're going, I think I'll declare bankruptcy and keep whatever, asset protection law allows me to keep. So thinking of it that way, now we're talking about cars. Okay, how much is your car worth? So you bought a nice car. You bought a new car. It's worth $30,000 or $40,000. Maybe it's a really nice SUV. It's $60,000 or $70,000, right? Maybe you got a Tesla X. Maybe it's $120,000. But whatever it is, it's pretty small compared to that $5 or $10 million judgment against you. Yes, state asset protection laws, they're all over the board how much they'll protect, but typically they're only going to protect $1,000 or a few $1,000s of your car. So if you're having to declare bankruptcy because you have this huge judgment against you, you're probably losing the car, right? Unless it's a total beater, you're probably losing the car. You're having to sell it at least, and maybe you got to keep $1,000 of what it's worth, and the rest is going to your creditor. All right, so this is it's pretty small change when it comes to the big asset protection picture. So when I think about asset protection strategies, and Katie and I have put some asset protection strategies in place, the vast majority of our assets would be protected in the event of some huge judgment against us. But we didn't put the cars in there. You know what? If we have to declare bankruptcy, they're going to get the cars. Enjoy. Right? But it's such a tiny percentage of our wealth that it's really not going to move the needle. We'll turn around and we'll go buy new cars, and that'll be okay. Okay. So if you have serious asset protection concerns because you have a serious amount of assets, your cars probably shouldn't be the thing you're worrying about. That said, when things are easy to do, when asset protection moves are easy, things like tenants by the entirety, right? That's an easy thing to do. It doesn't cost you anything. You might as well do it, right? And you would have to talk to an expert in creditor-debtor law in your state as to how much of a difference this would make in your situation. But typically, when you title something as tenants by the entirety, you title it as Joe and Jane Smith, husband and wife. not husband or wife. It sounds to me like somebody just got confused at the dealership. So maybe that's worth spending a few bucks to change the title. I probably would. Tenants by the entirety doesn't work in my state, though, so it's not really an option for me. We have to use a totally different strategy, it turns out, in order to protect our home equity, and obviously, brokerage accounts, and we haven't bothered doing anything by the cars. We just own our cars in our own names, which is probably fine, I suppose, for my old beat up Sequoia. But I guess if I had a really nice car, maybe I'd think twice about it. If you want your questions answered by the White Coat Investor, record your question at whitecoatinvestor.com/YQA or click the link in the description.
The hosts of the White Coat Investor podcast are not licensed accountants, attorneys, or financial advisors. This podcast is free entertainment and information only. It should not be considered professional or personalized financial advice. You should consult the appropriate professional for specific advice relating to your situation.